the jury that it should consider Joseph Hembrough's prior consistent statements solely for rehabilitative purposes. In this case, the state has not advanced an argument to the contrary. Therefore, the only issue before this court is whether trial counsel's deficient performance prejudiced Kelton Galmore. And the answer is yes. Given that no physical evidence linked Galmore to the robbery and murders, the state's case rested on the credibility of Hembrough, who was a 5-time felon, established drug dealer, and admitted liar. Hembrough, who was 11 years older than Galmore, did everything possible to minimize his role, despite the fact that he was the mastermind behind the crimes, where he was heard planning the robbery and showed up to Savante English's house armed and wearing body armor. Given the issues with Galmore's credibility, the state heavily relied on the cell phone number and the Snapchat profile attributed to Galmore to corroborate Hembrough's testimony. The jury, however, would have not heard or considered this evidence had defense counsel objected to their admissibility, because the state failed to establish that they did not, in fact, belong to Galmore. Alone, or certainly in combination, counsel's errors deprived Galmore of effective assistance of counsel, and this court should reverse his convictions and remand for a new trial. Turning to my first point, Your Honors, as Your Honors found in McLean's unpublished decision, Galmore's trial counsel should have requested an instruction informing the jury to use Hembrough's statements to Michael Pullings for rehabilitative purposes only. And counsel's failure in this case to request the limiting instruction was not reasonable trial strategy, where counsel had objected to the admission of Hembrough's prior statements, pre-trial and even at trial. So therefore, it's inexplicable that counsel stood mute when the state in rebuttal argued that Hembrough's statements to Pullings that he, Fats, who had been identified as Galmore in court, and a white guy from Springfield went to the house, and Fats shot the man with gold teeth with a sort of automatic weapon like an Uzi. Essentially, this is an error because our Supreme Court has noted that when the state argues that a prior consistent statement is the truth, and the jury is not instructed that the evidence should be used for a limited purpose, the statement is being used as substantive evidence. And that's exactly what happened here. Moreover, the error was particularly egregious since the state suggested to the jury that Hembrough's prior consistent statements for the truth were the last thing they heard in rebuttal before they retired to the jury room to deliberate. Moreover, counsel's deficient performance here prejudiced Galmore because without Pullings' testimony, the remaining evidence was far from overwhelming as to Mr. Galmore's guilt. Again, there was no physical evidence connecting Galmore to the crimes. There was no DNA, no fingerprints. Galmore did not make an inculpatory statement. No gun or phone attributed to Galmore were recovered. And the video surveillance footage and Comcast door logs merely showed that Hembrough was driving the red car belonging to his girlfriend, the red Mercury Milan, near English's house, and that 3 individuals stood on the front of the porch after 1 a.m. on August 9th, 2021. So then without that, the case rests totally on the credibility of Hembrough, which was highly questionable. Hembrough was less than forthcoming. He changed his testimony as to his role in the incidents 3 times. Initially, he completely denied any involvement or participation in the murders and tried to put the blame on the much younger Hembrough and Larry McLean. Not until February 2022.
Counsel, if I may, and I know you're arguing the credibility issues, but wasn't Hembrough's testimony otherwise corroborated by some of the surveillance video, as well as the cell phone location data, the call logs, and some of the ballistics evidence at the scene?
So the surveillance video and the ballistics show that, in fact, a robbery occurred and that a homicide happened and that 3 people, one being for sure Hembrow, participated. Now, the issue with the phone is, and this is why it shouldn't have come in, and counsel was ineffective for failing to object to it, is that the phone, there was no cell phone recovered from Galmore. The only thing we had were phone records for that cell phone number, but the subscriber info did not list Galmore as the subscriber. So then to tie the phone number to Mr. Galmore, they relied on Hembrow's testimony. And again, this was not reasonable trial strategy for trial counsel to not object. At trial, he recognized there was not enough foundation for the cell phone records, the subscriber records, and he objected. And the state agreed. They're like, yeah, we'll lay more foundation. We need to lay more foundation. But then they didn't. They just admitted, they moved to admit the CD with the records and the certification form, which would have been fine if the subscriber records listed Galmore or somebody who was related to Galmore as a subscriber, but that didn't happen here. And there is some doubts as to Hembrow's credibility as to whether the contact that he saved under My Favorite Fat Boy belonged to Mr. Hembrow. And if we look at it, it wasn't the first time that he talked to the detectives. And this is when he was denying his involvement completely and was pointing it all out, was trying to lay the blame on Hembrow and McLean. And he was very motivated to do this. He had an incentive to lie because Hembrow had a drug business to run. That's part of the reason this robbery even occurred. His girlfriend heard him the night before talking about hitting a lick. And at trial, Hembrow did say, I was driving up to 14 hours to get drugs for my customers. He was dealing meth and other drugs, and he was looking for something closer. He was looking for a closer connect. And he was able to get $8,000 from his people to go buy drugs from English and Williams. But then what happened to that money, we don't know. After the robbery, he benefited from wanting to stay out of jail because he was allowed later, he was able to make drops and then enjoy the proceeds and went immediately to the mall to buy him and his girlfriend clothes, tapestries, and other shoes. So there was this incentive. And again, the records suggest that he was also the mastermind behind this. Aside from hearing him plant, he showed up to the house wearing body armor and armed with a gun. He also was very pivotal as to what happened. It seemed like he was the leader where at one point he suggested to his 2 companions, hey, if we're looking for this money in the Dodge Challenger trunk, maybe we should shoot the lock of the trunk. And then he changed his mind and said, no, that would be, that would call too much attention to us. And then when they get home, he's the one who distributes the share of the drugs. He also orders McLean to take off his clothes and burn them. And then he orders Stephen McFadden, who was his roommate, to give McLean a pair of clothes, and later paid him $100 to pick up bullets from the yard. So therefore, the phone, the phone and the Snapchat as well are problematic and cannot be attributed to Mr. Galmore because there was not sufficient foundation laid, and counsel should have objected to that. Again, as to the Snapchat, the problem with the Snapchat is it relied again on the number that Mr. Hembrow identified it, and he's the one who created that contact information. He has shown he's a sophisticated criminal, so it is plausible that he's the one who had something to do with the creation of the profile. I mean, that's something that the cases that we cited, I believe Brand and Kent in the opening brief, talk about why we need sufficient foundation for social media accounts such as Snapchat, because it's so easy to be able to just download the app and enter generally known information to create that account. And that's what happened here.
Just to follow up on a question.
Sure.
The Snapchat profile was used to corroborate his testimony connecting the phone number to the defendant, but it was not otherwise used as substantive evidence, correct?
Correct, Your Honor. The only substantive evidence that came through was related to the victim's Snapchat accounts against Larry McLean, but no substantive evidence. You're right. And so again, what it was the Snapchat, what it had its profile, it had as the name of the profile, Mr. Galmore's nickname, which was known to the greater community of his friends, and that included Joseph Hembrow. Therefore, without Pauline's testimony and without the cell phone records and the Snapchat profile attributed to Galmore, the state's case slowly lies on the shaky credibility of Hembrow, and that is, it might have been sufficient for a conviction, but it's not in this case because it seriously undermines the outcome, and the outcome could have been different without this evidence. If your honors have no more questions, I will just ask that these errors by counsel, either individually or combined together, were deficient and they prejudiced Mr. Galmore. So we would ask that this court reverse his convictions and remand for a new trial. Thank you.
Thank you. Counsel for the appellee, you may proceed with your argument.
Thank you, Your Honor. May it please the court, counsel. My name is James Ryan Williams, and it is my privilege to represent the state before this honorable court. As Justice Lannard alluded to a moment ago, the co-defendant in this case was believable not because of some prior consistent statement that was admitted, but because he told the truth. And that truth, as the truth often does, was matched the all of the physical evidence. The independent evidence corroborated the co-defendant's version of events. So as was discussed, there's of course the surveillance camera that from the neighbors that captured 3 individuals on the porch at approximately 1:05 a.m. It also captured a maroon car that had a distinctive silver panel on it that perfectly matched the car that Mr. Hembrow borrowed from his girlfriend and drove to the scene of the crime with the defendant and the other co-defendant. Of course, you have the Comcast door logs that corroborate this timeline. And then perhaps most importantly is the cell site data that places, I think that's what it was referred to, that places the defendant and the 2 co-defendants together, moving together between Springfield and Jacksonville and Springfield at times that are corroborated, that, otherwise corroborate the timeline. Then of course, there's the fact that defendant changed his phone number the very next day. And then the location and caliber of the 9mm shells match the sequence of events. And going back to the cell site data, I mean, I'm not sure that I understood it correctly, but it sounds like there was some suggestion a moment ago that I guess the co-defendant, Mr. Hembrow, created or got a second cell phone and an unknown name, created a Snapchat profile that was linked, that could be linked to the defendant, and then took that phone with him as a third phone in the car without an owner of that phone to and from. I mean, it just doesn't make a lot of sense that introduces any doubt here that there's some third phone that's traveling with them that's coincidentally tied to the nickname. I mean, if that was the case, why wouldn't you just, if you were going to just use the guy's actual name instead of, anyhow. But again, overall, with respect to all these alleged errors by the court, all of this allegedly deficient performance by counsel, at the end of the day, respectfully, it's entirely harmless and not at all prejudicial because the evidence is overwhelming in this case. And unless this court has any further questions,
I would like to just clarify one issue. I know the defendant's argument seems to focus a lot on McLean's cell phone records, the co-defendants. However, as far as the defendant's own cell phone records, wasn't there a certificate of authenticity for the defendant's records that stated they were made under the oath? Isn't the focus really on the co-defendant's certificates lacking the statement under oath?
On the T-Mobile records?
On the defendant, yes, on the cell location data, the T-Mobile certificates.
And I'm sorry, Your Honor, is your question regarding the lack of the under oath statement?
Which my question is, I believe if there's sufficient argument that impacted the co-defendant McLean. But as far as the defendant Galmore's own records, were those certificates made under oath?
I think you're referring to the fact that the certificate omitted the words under oath. So I guess in that sense,
was it for both co-defendants though, or only one?
I'm not sure, Your Honor.
Okay, thank you.
I don't know. I'm very sorry.
That's okay.
Are there any other questions? Okay, thank you for your time.
Could I ask a question before we get to rebuttal? Mr. Williams, this wasn't explored in the opening argument, but I have a question relating to the claim by defendant that the state made some improper comments during closing argument relative to Hembrough's plea deal. And there was a suggestion that the state in its argument indicated that the trial court had already determined that Hembrough had testified truthfully or something along those lines. Can you just tell me what your interpretation is to what the argument was made by the state relative to the court's involvement in determining whether Hembrough had abided by the terms of the plea agreement?
Frankly, Your Honor, I feel like that argument is really based on a totally unfair extrapolation of what the state was arguing. My recollection of what the state's argument was there is they were essentially just addressing the terms of the plea agreement, which is not uncommon to do, referencing the fact that the co-defendant had to testify truthfully. That's allowed by case law cited in my brief, and merely reference the fact that it's the trial court that determines if he had testified truthfully, and if it determines that he doesn't testify truthfully, it can violate the terms of the plea agreement, thereby subjecting him to a potential life sentence. So my reading of that was just simply not that it was at all improper vouching, but I honestly don't see, reading the words on the page, I don't see how you jump to the conclusion that somehow suggested the court had already determined that the co-defendant had testified truthfully. But rather, if the court happened to determine that the co-defendant did not testify truthfully, then presumably at some different hearing outside of the presence of the jury, it could blow up the plea agreement, for lack of a better word. So again, I just don't think that when you actually read it in full context, instead of a couple words quoted here, filled in, a couple words quoted here, and then try to extrapolate that meant that the state was arguing the court had already determined he was testifying truthfully. I just ultimately think that that's just an entirely unfair extrapolation of the statements that were made by the state.
Okay, thank you.
Thank you for your time, Your Honor.
Thank you. Counsel, rebuttal?
Yes, to answer your question, Justice Leonard, for the purposes of time, we didn't address that issue, but we did raise the issue that the certification was deficient for the T-Mobile records because there was no mention that they were under oath and therefore didn't comply with Rule 90211. It's in
But are you
page.
referencing defendant Galmore or co-defendant McLean?
We're referencing defendant Galmore because the error was also in Galmore's records. And it was more particularly egregious because, again, also the subscriber cell phone records did not list Mr. Galmore as the subscriber. Now, as to the issue about the state's point about the whole thing about not making sense of the phones, I mean, if we are taking the position of the state that Pembroke was being truthful, he admitted through his own words that two things: Galmore had multiple phones and that he traded phones with Galmore, and they had done this several times. So it's not incredible to believe that he had the phone with him on that night. Again, it's questionable given the fact, again, that that's what Galmore, that Pembroke said himself. And he also said that they had Mr. Galmore had multiple phones and they were traded, and specifically with him. And as to the question about the plea, again, because the credibility issues with Mr. Hembro's testimony, it was improper vouching. And the comments were not isolated. They were all, everything talking about the plea and whether saying that they had already determined that Hembro had been truthful. That was all said in one part in the same section of the closing arguments. And again, it just goes to show that the state realized that they didn't have enough based solely on using Hembro's testimony, and they needed additional information to corroborate.
Counsel, may I ask you just to clarify, is your argument on appeal in part that the state suggested to the jury an argument that the trial court had already determined that Pembroke had abided by the terms of the plea agreement and that he had testified truthfully?
Yes, Your Honor. That is our position.
Portion of what words are you pointing to in the argument that indicate that?
Sure, if you give me 1 second. Yeah. I'm sorry, Your Honor.
That's okay.
I just want to make sure I give you the correct portions of it.
It might be around page 2000 of the record.
Okay. Yes. I believe it's 1985, Your Honor.
You said page 1985?
Yes, it starts with, not only would Hembro lose 20 years of his life, he had to tell the truth. And if he didn't, that 20 years, it's gone. And he's looking at a potential life sentence and not his version of the truth. Not even what the prosecutor's about to hear, the truth. The judge decides that. And so Joe is not thinking to himself, what can I get away with? He is motivated to be truthful now.
Okay, so what I heard you read, though, it says the judge decides that. It doesn't say the judge decided that.
Correct, but he
Past
had
tense
already
versus future tense.
correct. The only thing is that he had already at this time, and this came out at trial, at this time of his testimony, Hembro had already pled guilty. And the judge had already accepted the plea bargain, the plea deal. So that's our position as to why the judge had already been decided, and the jury had this information before them.
Well, the term of the plea agreement that is at issue is whether or not defendant testified truthfully. At the time of the plea agreement, he hasn't testified, obviously. So how can you say that the judge had already determined that Hembro had testified truthfully?
Well, Well, based on what was proffered to him at the plea hearing, if he had not heard, sufficient or just, information to believe that he would be testifying, truthfully, would he even have accepted the plea? No. So that's our position, Your Honor.
Okay, thank you.
You're welcome. And for the reasons stated today and in our opening brief, we ask this court to reverse Galmore's convictions and remand for a new trial. Thank you.
Thank you, counsel. The court will take this matter under advisement and the court stands in recess.